Velina me ke aloha. Welcome to the Lahui Rising series. This educational series is designed to create a safe, respectful, and enriching learning space for all audiences to hear and honor various perspectives on matters of Hawaiian interest. The content of the presentation shown in the Lahui Rising series may not necessarily reflect the views of Kamehameha schools. However, we hope this series will encourage openness and respect for differing views on Hawaiian issues and stimulate discussion and action towards positive change for our Lahui Hawaii.
Our first presenter really needs no introduction, but Dr. Keanu Sai has a PhD in political science from the University of Hawaii, specializing in international relations and public law. He has taught extensively throughout the University of Hawaii system and presented even more extensively throughout the world, including at the University of Cambridge, Harvard University, New York University, and Smithsonian Museum in Washington, D.C. He's the author of the textbook Ua Mau Ke Ea and numerous academic articles, including a book chapter soon to be released by Oxford University Press. Please welcome Dr. Keanu Sai.
So before I can provide a better understanding of the Permanent Court of Arbitration and the proceedings that have taken place from 1999 to 2001, so here we are at the Permanent Court of Arbitration during oral hearings in the year 2000, December. Now you have to keep in mind, this is not the Hawaiian Kingdom case. This is actually Lance Larson coming after the Hawaiian Kingdom for not protecting him because he went through a trial and incarceration under American law. So his attorney was alleging that the acting government, the provisional government, was negligent for allowing American laws to be imposed in Hawaii, which led to her client's incarceration. That's the issue that was taken to the court.
On April 8, 1842, King Kamehameha III and Privy Council commissions 3 envoys to secure international recognition of Hawaiian independence. And these individuals are Timoteo Ha'alilio, William Richards, and Sir George Simpson. On December 19, 1842, Hawaiian envoys secured United States President Tyler's recognition of Hawaiian independence. November 28, 1843, the British government and the French government formally enter into a declaration recognizing Hawaiian independence. In our pleadings, we refer to that as the 1843 Anglo-Franco Proclamation. From that point, Hawaii has had its statehood recognized as being independent. As such, it began to enter into these treaties: Austria-Hungary, Denmark, France, Germany, Great Britain, Italy, Japan, Netherlands, Russia, Spain, and the United States of America. International recognition is evidence that the Hawaiian Kingdom have diplomatic representatives as of 1893 from those countries, as far as consulates and embassies.
We need to understand the difference between national laws and international laws. So here we have the 2 countries, the Hawaiian Kingdom and the United States. In 1898, the United States passed a law called the Joint Resolution of Annexation.
In 1898, with the support of newly elected William McKinley, the Republic of Hawaii, in league with the United States, orchestrated a treaty ceremony on the steps of Iolani Palace. One can only speculate why the United States would either suggest or participate in acting out the motions of exchanging a treaty without an actual treaty. Children have a name for this. It's called make-believe.
That law is an American law, or what we call national law, as opposed to international law, which is a law between nations. A national law is limited to effect within a nation. 2 years later, the United States Congress passed another law called the Organic Act, establishing the territorial government, or just changing the name from the Republic, which used to be the Provisional, which used to be the Hawaiian Kingdom. Merely name change. But again, to stress the point, this is a national law of the United States.
In 1900, the U.S. Congress passes an act to establish a civil government to be called the Territory of Hawaii. To add insult to injury, President McKinley appoints one of the principal saboteurs, Sanford B. Dole, as governor. Consider for a moment the mindset of nearly every person of Hawaiian nationality in 1900. Their rights abducted. Their property confiscated by the very individuals who once swore to defend the kingdom against all enemies. Their queen imprisoned by foreigners and traitors. Their flag removed from all public places and supplanted with the flag of another. Their language, culture, and traditions destined for eradication, struggling to exist under a largely cultureless foreign government. These are just the obvious realities to consider as the beleaguered kingdom limped into the 20th century.
Then in 1959, the United States Congress passed another law changing the name from the Territory of Hawaii to the State of Hawaii. And then in 1993, the United States Congress passed a law apologizing for the illegal overthrow of the Hawaiian Kingdom government. But within that apology law, they used terminology that is very similar to and a part of what is called federal Indian law. So terms such as indigenous people, self-determination, that's the terminology that applies to within the federal Indian law, which is within the United States law. And then in Act 195, 2011, Kana Iolowalu. Okay. Now, what we have as far as the genealogy of all these laws is that they are U.S. laws. Now, U.S. laws have no enforcement in another country. Okay, so the United States in 1898 could no more pass a law annexing Hawaii than it could pass a law today annexing Canada, because it's limited to its territory. And that's part of U.S. constitutional law, a very recognized principle. But international law, which is not national law, international law is a law between nations, and that's what we call treaties, customary international law. In this case, what regulates Hawaii's situation is the international laws of occupation, which is the Hague and the Geneva Conventions. So the United States Supreme Court, this is the authority of U.S. law, okay, within the United States. And it specifically states here, back in 1824, in the case the Apollon, the laws of no nation can justly extend beyond its own territories. They can have no force to control the sovereignty of any other nation. In 1936, the United States Supreme Court reiterated that position and said neither the Constitution nor the laws passed in pursuant of it have any force in foreign territory. So here's a visual to explain this. This is the United States of America. What you have there is Washington, D.C., where the U.S. Congress is situated. You have borders. U.S. laws have no effect beyond the borders of the United States. So according to the U.S. Supreme Court, we use them as a guide. It says that when the United States is in foreign territory, it must be governed by treaties, international understandings and compacts, and the principles of international law. That's pretty much the framework that needs to be understood with regard to these facts of our history, our country.
It has been 118 years since that January day in 1893, when the hushed business of the capital city was shattered by the sounds of American imperialism marching through her streets. Unwarranted, uninvited, and unwanted, American Marines marched to Iolani Palace and targeted the Hawaiian throne.
No lawful government. All the governments that came were declared in Hawaii after 1893 were all based upon U.S. law from the United States Congress. If the United States Congress has no effect in Hawaii, then these governments cannot claim to be real governments. So, from a legal standpoint, since 1893, there has been no lawful government. Now, the Permanent Court of Arbitration, as Umi had pointed out, was established in 1899 by the Hague Convention number 1. And in this, at the Permanent Court of Arbitration, they provide services to resolve disputes. Now, the Permanent Court of Arbitration is an intergovernmental organization. Their job is to create tribunals to address particular disputes, in particular, ad hoc tribunals. You don't have standing tribunals, ad hoc. Yeah? And once they receive a dispute, they first have to determine whether or not it is an international dispute, because private people cannot go to the Permanent Court of Arbitration. One of the parties has to be a state. A state. Remember that diagram I showed you? The Hawaiian state still exists despite the government being overthrown. And this is the case that I was a part of, Lance Larson versus the Hawaiian Kingdom. They also can hear cases or establish tribunals between a state and a private entity. So there's the Larson versus the Hawaiian Kingdom, case repository. If you notice, they identify Lance Paul Larson as the private entity and the Hawaiian Kingdom as a state. This is very profound. So what came out of this, the court? What the court did was it verified that Hawaii was an independent state in the 19th century. The court could not rule on the lawfulness of the conduct of a state called the Hawaiian Kingdom when its judgment would imply an evaluation of the lawfulness of the conduct of another state which is not a party to the case. The biggest confusion that has taken place with people looking into this arbitration decision, they thought that it was about whether or not the Hawaiian Kingdom exists. No. We were there arguing this case before the tribunal because the Hawaiian Kingdom exists. The Permanent Court of Arbitration would have never started it from the beginning unless they could verify the kingdom's existence.
Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is, in a sense, to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter, which is actually what is holding up, you might say, this issue to be resolved. Thus, the legal order, thus, the reestablishment of the government, thus, the relationship between its nationals.
I mean, to be slightly unkind, but thus the issue in rem. The point is that if the Hawaiian Kingdom continues to exist, its existence is in rem. It's not in personam. The Hawaiian existence, the Hawaiian Kingdom doesn't exist solely in the opinion of Mr. Larson.
Right. But that existence should not be dependent upon an occupier, because you basically put the occupier on an equal footing with the Hawaiian Kingdom in its own territory. So really what needs to be addressed is what came before the occupation, whether the statehood or whether the legality or illegality of the Hawaiian Kingdom, not the illegality or legality of the United States as an occupier.
This was a dispute between Larson and the Hawaiian Kingdom. The arbitral tribunal said, well, possibly you can get around the indispensable third party rule if you go to fact finding. So it stated at one stage of the proceedings, the question was raised whether some of the issues which the parties wish to present might not be dealt with by way of fact-finding process. In addition to its role as facilitator of international arbitration and conciliation, the Permanent Court of Arbitration has various procedures for fact-finding, both as between states and otherwise, a state and a private entity. But what's more important here with this South China Sea case is not necessarily the $30 million costs, but they also address the indispensable third-party rule. And up to that point, the only precedent cases on the indispensable third-party rule would be Monetary Gold, removed from Rome in 1943, and the East Timor case, which both were cited in the Larson Award. Well, this is the decision made by the South China Sea Tribunal. Paragraph 181 of its award on jurisdiction. The present situation is different from the few cases in which an international court or tribunal has declined to proceed due to the absence of an indispensable third party, namely Monetary Gold, which you saw was cited in the case, in the arbitral award for the Hawaiian Kingdom, East Timor, another one cited, and Lance Larson versus Hawaiian Kingdom. So the Lance Larson versus Hawaiian Kingdom case is a recognized principle now that is used in all international law cases that come before the international court or tribunal with regard to the indispensable third party. So this speaks to the legitimacy and the authenticity of the case itself, despite the misunderstanding and misconceptions that have taken place from people here in Hawaii.
I'd just like to say that we're truly honored to have as our guest tonight someone of very high caliber. Dr. Federico Lenzerini is professor of international law at the University of Siena, Italy. Is a PhD from the University of Bari and is also professor at St. Thomas University in Florida in the School of Law in the LLM program in intercultural human rights. He's been a consultant to UNESCO. He's the author of 5 books, 2 from Oxford University Press, and get this, over 90 academic articles. I should also mention that he will be the counsel and advocate for the Hawaiian Kingdom, or he is the counsel and advocate for the Hawaiian Kingdom in the Fact-Finding Commission of Inquiry. Please welcome Dr. Federico Lenzerini.
Aloha maikaku. The Hawaiian Kingdom entered into a special agreement with Lance Paul Larsen to form an international commission of inquiry, which I will define the commission under Part 3 of the 1907 Hague Convention for the Pacific Settlement of International Disputes. The commission will have to decide on these points. First of all, it should determine what is the function and role of the government of the Hawaiian Kingdom in accordance with the rules of international humanitarian law. Second, it should assess, again on the basis of the rules of international humanitarian law, what are the duties and obligations of the government of the Hawaiian Kingdom toward Lance Paul Larsen, and a fortiori toward all Hawaiian subjects residing in Hawaii and abroad, and finally, towards aliens who, when they visit Hawaii, like myself, for example, are subject to regulations in force in the Hawaiian territory. It is a special branch of international law regulating the conduct of armed conflicts. International humanitarian law originated in 1815 at the Vienna Congress, when the European powers realized that sometimes war was unnecessarily cruel, and it was possible to enter into armed conflicts and at the same time reducing the suffering of people. As far as Hawaii is concerned, war crimes in the occupation of the Hawaiian Kingdom might include, among others, denationalization, destruction of civilian property, pillage, destruction or appropriation of public property belonging to the occupied state, omission of administering the laws of the occupied country, depriving individuals of a fair and regular trial, unlawful deportation, transfer, or confinement. So this issue of war crimes will inevitably go in front of the Commission, of the International Commission of Inquiry. This assessment, as I was saying, will include an investigation of whether during the last decades war crimes have been committed in the Hawaiian territory. I have to say that this is probably the most important outcome to be pursued in this moment, because in order to achieve whatever goal, knowledge, consciousness of history and the reality is essential. Myself was unaware, was ignorant of what really happened in Hawaii. And when I met Dr. Tsai and I realized the reality of your history, then I decided to ascertain what is the status of international law of the Hawaiian Kingdom in consideration of this history. And this is the reason why I have decided to get on board. Okay.
Mahalo. What can Hawaiian Kingdom subjects do to kako'o or support the restoration and support the independence of the government?
In my opinion, first of all, to believe in your belonging to the Hawaiian Kingdom. To be aware of the value of your identity and to do what you're doing right now. I am just an example. I am here tonight. I am an Italian citizen who, until a few months ago, totally ignored the reality of the situation of Hawaii. The more international support you obtain, the more the action of the Hawaiian Kingdom can be effective. But I repeat that the most important thing is not to surrender, is to continue to believe that you belong to the Hawaiian Kingdom and that you don't want to lose your identity as the Hawaiian Kingdom.
Mahalo Anui, on behalf of the Kaiwa Kilo Moku Hawaiian Cultural Series, Kamehameha Schools Kapalama Social Studies Department, and the Parent Fund. Mahalo Anui Kahele Anamai, e pupa kai kako me ka mea ai mama o waho. Aloha.